Most gracious and most heavenly Father, again, we say thank you. Thank you, O God, because for some strange reason you decided to wake each and every one of us up this morning. You didn't have to, but yet you did. So we believe, Lord and Father, since you touched us, that there's something that you want us to do. So we ask and we pray that you would give us the strength, give us the courage, give us the sight, give us everything that we need to be all that you have called us to be. And then we thank you for Dr. Barber, the NAACP. We thank you for how you use him and how you strengthen him. We thank you for the words that you give him in the midnight hour, and we thank you for the strength you give him in the morning. So God, we ask and we pray that you continue on doing it for him. And then God, whatever way that we can be used to help him, to help the NAACP, to just be mighty men and women of your desire. We ask that you would pinch us and nudge us to make sure that we hear it and hear it clearly. And now on this morning, we ask and we pray that your Holy Spirit fall down upon us. Break us, make us, feel us. Spirit of a living God, fall fresh on us. And whatever you do, we'll be satisfied with it. This is your house. You have your way. And if you do that, we'll be sure to give you the glory, the honor, and the praise. And if by any chance this is the last time that we may see each other, that the next time we open up our eyes, we'll be able to see you, and you will say, job well done. In Jesus Christ we say amen.
Amen. Thank you, Pastor Cooper. My name is Derek Smith. I'm the Political Action Chair for the State Conference of the chapters of the North Carolina NAACP. And today it is an honor to open up this press conference as we will commemorate, we'll celebrate, and we're going to activate some plans surrounding voting here in North Carolina. As you know, August 6th, 1965, 51 years ago, the House of Representatives mustered up over 320 votes, the Senate over 77, around 77 votes. A House of Representatives which had Southern Dixiecrats and segregationists, and a Senate which also was full of people who were resistant to African American voter enfranchisement. And we had a president who was a former segregationist from Texas. They mustered up the political will to pass the Voting Rights Act in 1965. Today, there is no such political will, as after Shelby versus Holder in 2013, Congress still has not acted to reinvigorate those provisions of the Voting Rights Act, which will give us those full protections. So we commemorate what the Voting Rights Act was prior to 2013, but we also lament at the fact that it is not what it should be. And we are also here to celebrate our victory with the Fourth Circuit Court of Appeals decision last week. And their refusal to honor the state's request to continue to discriminate, just recently decided this week. So this is a great day across the state of North Carolina. It's always a good day to be involved in political action. But we have to be mindful that we must continue to mobilize. So the third part of what we're here for today is to activate mobilization plans to ensure that we continue to protect this franchise, because the struggle is still real. It's important to point out that, and Bob Hall is here, and I'm sure he's going to let us know a little bit more about since the Fourth Circuit decision, even in Guilford County, there are plans to restrict early voting, and so we'll be meeting in Guilford County on Monday to let the Board of Elections know that they need to do the right thing and to make sure that we're able to fully enjoy our new rights, even though they aren't new. But they've been handed to us again. So at this time, I would like to bring up our leader, the architect of the Moral Monday Forward Together movement, Reverend William J. Barber II, a person who we all believe is the person who has that moral clarity to bring back fusion and inclusion to the state of North Carolina and to this nation. So here's our beloved Reverend Dr. William J. Barber II.
Thank you so much. First of all, I want to invite all of those who just came in, come on up if you can. If you can make it around the sides and come up. We see everybody knows where that pocketbook is. We all right. And Miss Carolyn Q. Coleman, who's one of our, I don't know if we can make an adjustment for just a moment, but it's important because she's one of our plaintiffs, and I want to make sure. First of all, let's give, when Dr. King was in Montgomery, and they were about to put him in jail for running an illegal traveling agency, basically. They said a rustle started in the back of the courtroom, Ms. Coleman. A rustle started in the back of the court. They're gonna move, Ms. Coleman. Yeah, come on. We want you up here with us. Yeah, a rustle started in the back of the courtroom, and somebody gave him a piece of paper, and on it said that the Supreme Court had just ruled that segregation in public accommodation was unconstitutional. And they said an old illiterate deacon who was he could not read but could read the signs of the time, said, "My God, the Lord has spoken from Washington, D.C." Where on last Friday, my God, the Lord has spoken from the Fourth Circuit. And we ought to first, if you can't clap, just give a big shout to the grace and the strength of the moral arc of the universe for all that we have seen over these 3 years. Then I want us to give a big hand to those people who signed up to be plaintiffs, starting with our 3 matriarchs. Sister Eaton, give a hand, Sister Perry, and Sister Carolyn Q. Coleman. They were our lead matriarchs in this battle, this over 3-year battle. We're good. We take time for each other. That's right. Because we understand that it takes all of us to win these battles. And you know, we fought for more than 3 years. Also, I want to, I remember during the case, all the diversity, and on our team, you would see women and men and young people and Latinos and students on our team. I won't talk about anything on our team. And amazing to me in this moment what we saw coming together. So I want to celebrate the sisters too that helped lead us in this legal case. Our lead attorney, Penda Hare, the powerful and brilliant Allison Riggs, who is here. This sister was on it. Caitlin Swain, who's here, Anita Earls, and then also the brothers that were there, the others who served early on, Danita and Denise Lieberman, and then Irv Joyner, and Adam Stein, and Al McShirley, who was always on the side reminding us about history and telling us never to give up the fight. And I want to say a few things this morning about this case in particular on this day. This is the 51st anniversary of the Voting Rights Act. Think about it. And the fact of the matter is, in 2013 with the Shelby case, Section 4 of the Voting Rights Act was nullified, thereby undermining the power and implementation of Section 5, which is pre-clearance. And if pre-clearance had been in place, none of the things that this legislature did would have passed pre-clearance. We need to understand that. But Section 2 was still in place. The Constitution, the 14th Amendment, the 15th Amendment were still in place. And our lawyers set out with our plaintiffs to prove that voting rights and equal protection under the law is still the law of the land. And no governor or legislature has the authority to run roughshod over the Constitution. None. Maybe they thought that we wouldn't fight because we didn't have pre-clearance. Maybe they thought we wouldn't fight because they had more money than we had. Maybe they thought we wouldn't fight because it would take a long time. But we've always had less money, but we've always had more battles to fight. But what we know is every battle for justice we've ever fought, we've always eventually won. Now, I want to say a few things, and then I want to ask our plaintiffs, attorneys to have a comments, because even now, Section 5 is still not operative. And the Congress of these United States, and many of our congresspersons, have spent over 1,100 days. I was counting it day by day. I had gotten up to 1,131, and I stopped counting. But they have filibustered fixing the Voting Rights Act more than 1,000 days longer than Strom Thurmond filibustered the 1957 Civil Rights Act. And that's shameful. Because once the courts ruled, they put it in the hands of the Congress, and the 15th Amendment says the Congress has to protect and has to make these laws, and they have refused. That's McConnell and Ryan and before them, Boehner. They've refused to even let it come up for hearings. And that's why I contend in this political season, it's not just people's tone that troubles us. It's the trajectory of their policy. And that's why we in the NAACP, when somebody say, is someone racist, and it's in their heart, we say, we don't know about their heart. We look at the heart of their policies. And if the heart of their policies are discriminatory, and then you support that is discriminatory, then you have said who you are without us having to say a thing. And 51 years after the Voting Rights Act, for us to be here today on the 6th of August, and with a bill which came about because of the blood and sweat and tears of black, white, brown, young people, and a Republican and a Democrat filed the original bill. 51 years ago, Republicans and Democrats, Carolyn, could come together and do the right thing. Put down, party for a minute, and pick up principle. And yet 51 years later, the current Congress can't do that. That is shameful. And it should be troubling. And then in addition to that, I was thinking, and this pains me to have to say this today, but I'm reading Ephesians 4, and it says, speak the truth in love. This bill was never a voter ID bill. I want to say that to the media. It was never a photo ID bill. It was a complex, multifaceted voter suppression bill. It was never about fraud. Speaker Tillis, there's a tape out there, and I encourage the media on MSNBC where he was asked that question specifically, and he said, no, there's no evidence of fraud. He said it of his own lips. We already knew it. The studies had already been done. Now, it also pains, so I want to make that clear, but it pains me to say our governor's response. And the Bible tells us to pray for our leaders, but part of prayer is to be discerning and to speak truth in love. Our governor's responses to this decision sounds strangely similar, to two extreme political leaders, one past and one present. The first one is George Wallace. Now, I don't say that lightly or with any great joy, but George Wallace's rationale for interposition and nullification sounds strangely similar to what our governor is saying now about this decision. His response also sounds strangely similar to Donald Trump. Listen now, I want us to hear. But I want to tell you why. Because what Donald Trump does is when you can't debate the substance, you attack the judges. George Wallace engaged in interposition and nullification. That is a refusal to accept the ruling of a higher court. Now, the jurists in this case, and I want North Carolina and America to hear this, are above reproach. We've heard in recent days that these were Democratic jurists and they were doing this to help Hillary Clinton. We didn't pick the judges.
No.
The jurors are above reproach. In fact, the judge who wrote the opinion, Sister Perry, the judge who wrote the opinion in the final part was against us when we first went to the federal court. I mean, the same judge that wrote this opinion dissented when we asked for a temporary injunction. Huh? Now, once she got the whole record, she wrote this unanimous report. The second thing is, this decision was unanimous. Unanimous. And to suggest that these jurors, 2 white, 1 African American, conspired for partisan reason is in essence our governor saying they are corrupt, they are deceitful, and they are operating in contempt of the Constitution. And for a sitting governor and legislator, but for a sitting governor to suggest that these jurists who are above reproach in the Fourth Circuit operated for any other reason but according to the Constitution is troubling, it is deeply concerning, and it should give all North Carolinians pause regarding his leadership. Because in the 21st century, the best you can do in the public square is to use the rationale of George Wallace and the irrationale of Donald Trump. I'm just saying. Now, the case was a sea change. It's the biggest case in the last decade, the biggest case since Shelby. It sends shockwaves through the halls of jurisprudence about where we stand in terms of voting rights. The second highest court in the land found that Governor McCrory, the case was in the NAACP versus McCrory, never forget that, and other leaders of the North Carolina legislature intended. This is the highest standard in the law. Intended to discriminate against African Americans and other voters. Intended of color as they wrote these laws knowing that they would have a disproportionate impact. This is unconstitutional. And these laws were banned permanently in North Carolina the same day by order of Judge Schroeder of the Middle District. Now, for the media and for those listening by live stream, what this means is this was not, oops, we made a mistake. This was not, well, we didn't know it would have this kind of impact.
That's right.
In the case, and I want just folk on the street corners and in the hood and everywhere, just basic language. What they did was they called their statistician and said, tell us, give us the stats on how black and white people use same-day registration.
Make it plain.
Give us the stats on how black and white people and Latinos use early voting. Give us the stats on how many black and white Latino people have the most stringent kind of photo ID. Tell us how black and white people use 16 and 17-year-olds out of precinct. And they asked for it.
That's right.
I want you to hear that. They asked for it. Now, we presented it to them, But even before, they requested the data. They requested, I want to say it again, they requested the data, which is one of the reasons we believe they would not come on the stand to defend what they had done. Media should note that. Not one legislator would come on the stand to defend what they had done, because they requested the data, and then based on the data telling them the overwhelming use of same-day registration by African Americans, the overwhelming use of same-day first week of early voting by African Americans, the disproportionate number of African Americans that didn't have this strict form of photo ID, the overwhelming use of African Americans registering 16 and 17-year-olds, and the overwhelming use of African Americans in terms of out-of-precinct voting, because sometimes polls are moved and those kind of things. They said, let's take it away. Notice what I said. We were not trying to pass same-day registration. We already had it. We already had early voting. We already had souls to the polls and Sunday voting. We already had out of precinct. What they did was like a laser. They went in and strategically removed it, and they removed it after North Carolina, particularly in the African American community, had some of the highest voter participation we have seen. Watch this. Watch this. Not that we have seen since 2000. Not that we had seen since the 1900s. Not that we had seen since the 1980s. But we had seen since the 19th century. The last time you had this many African Americans voting prior to this case was right after slavery, during Reconstruction, when voting was first opened up to African Americans, and you had high numbers, which then were undermined by the deconstruction. So we need to hear that. I'm deliberately being teaching, because folks need to understand, because there's been a lot of misstatements. I heard somebody on the TV the other night with Allison Riggs, that guy that was there, and he kept talking about this was positive and all this fraud. That's just propaganda. So since we try to deal in truth, let me just read from the case. Read it. This is from the case. This is not William Barber's word. This is straight from the case. This is what Justice Mott said in the writing. Faced with this record, we can only conclude that the North Carolina General Assembly enacted the challenge provisions of the law with discriminatory intent. That's page 11. All right? Page 23. We hold that the challenge provisions were enacted with racially discriminatory intent in violation of the Equal Protection Clause of the 14th Amendment and Section 2 of the Voting Rights Act, page 23. Using race as a proxy for party. They told us this was just about party, but when the judges examined it, they found using race as a proxy for party may be an effective way to win an election. But, this is the court, but intentionally targeting a particular race's access to the franchise because its members vote for a particular party in a predictable manner constitutes discriminatory purpose. It's good to have a record in it. Then the last one I want to read. Instead, it says, we recognize that elections have consequences, but winning an election does not empower anyone in any party to engage in purposeful racial discrimination. That's page 39. And then page 46 says, instead, this sequence of events, the General Assembly's eagerness to, at the historic moment of Shelby County's issuance, rush through the legislative process, the most restrictive voting law. Notice they don't call it photo ID. Asking the media not to call it. They call it the most restrictive voting law North Carolina has seen since Jim Crow. That's page 46. See that? That's page 46. Huh? That's page 46. See that? That's page 46. We didn't say that. Yeah, we didn't say that. No. Lastly, the record evidence plainly established race as a but-for cause. In sum, the array of electoral reforms the General Assembly pursued were not tailored to achieve its purported justification. In other words, to deal with fraud. A number of which were in all events insubstantial. In many ways, the challenge provisions constitute solutions in search of a problem. This is the judge now. In search of a problem. In the only clear factor linking these various reforms is their impact on the African American voter. Y'all heard what I said? The only thing that connects why they did what they did was the impact on African American voters. Now, while this is a victory last, we got work to do. And that's why after lunch, we're going to go to work not only about registration, but about voter protection, because already there are boards of elections who now are trying to play mischief.
Yeah, that's right.
And the mischief is we're going to operate by the letter of the law, but we're not going to operate by the spirit of the law. So we already got word in Greensboro, there's a possibility of people wanting to shut down the early voting sites on A&T's campus. Wow. And in Barber Park. Because the law says, you know, they don't have to have it, but at the Board of Election. But the spirit of the law is if early voting and all of these things help to increase the vote and overcome past vestiges of racism, and it's been proven that the General Assembly and the governor tried to remove it with discriminatory intent, then boards of election should not be lessening the sites. They should be expanding the sites. And I want to say here and now, the NAACP is going to expand our action and show up at every board of election. Today, we're training all of our branches and our friends how to go to every board of election, because we will not have a ruling by the courts that calls what you have done unconstitutional and then allow you to play mischief with the rules and still deny and suppress the right to vote. And we call on the media to go to these board of elections on this coming Monday, the ones that are meeting, and point out when people are still trying. Why is it? And I never will forget this question, and I'm through. When the male judge from South Carolina on this court asked one day the most poignant question. I looked at Ms. Rosendale, I was sitting beside, he said, why is it that there are people in North Carolina that don't want other people to vote?
Amen.
Could it be that you cannot win your case on your policy? You cannot make a case for North Carolina to support you on policy. So you attempt to use trickery in order to control the politics. We have never and we will never stand for that. We will fight every day for the heart of our democracy. Our attorneys have a comment and delete each of our plaintiffs. Make sure you all don't lock your knees now. You know, it's a little warm. You okay?
Good morning. Good morning. It's a good morning in North Carolina. I'm here today on behalf of Pinda Hare, Irv Joyner, Adam Stein, and the entire legal team that had the privilege of representing the North Carolina NAACP. A state conference led by Reverend Dr. William Barber, with more than 100 branches representing every county of this state, a mighty youth and college division, and an esteemed membership which includes the leadership of plaintiffs Carolyn Q. Coleman, Mary Perry, Rosanelle and Armenta Eaton, and Maria Palmer. Thank you to the congregations and organizational leadership of Emmanuel Baptist Church of Winston-Salem, Covenant Presbyterian Church, Barber's Chapel Missionary Baptist Church, and others who joined in this fight before it was the popular thing to do. Thank you to the executive committee and vice presidents. Thank you to the district directors, to the branch presidents, the legal redress chairs at the state and local level, the political action committee chairs, the branch secretaries, the youth and college members who stood up when other people sat down. This is your victory.
That's right.
Your legal team has drawn its direction, its course of action, and its moral compass from your leadership. The plaintiffs and membership of this organization would not accept open, targeted rollbacks to African American and Latino voting rights in 2013. You would not accept it in 2014. You would not accept it in 2015. And in 2016, we can celebrate this victory. I want to take one moment to remember the last time that I was in this church. And that was during a massive Moral Mondays campaign led by this coalition that cried out prior to the passage of this law to say, don't do it. This is wrong. The legislature did not listen then, but they must listen now. In the words of the Fourth Circuit victory, although the new provisions target African Americans with almost surgical precision, they constitute inapt remedies for the problems assertedly justifying them, and in fact, impose cures for problems that did not exist. We have heard this before, and we heard it from you. Within 1 hour of the governor's signature being affixed to this bill, the North Carolina NAACP filed a constitutional challenge and a challenge under the Voting Rights Act, Section 2, calling out the precise reasons that the Fourth Circuit has just ruled in your favor. And that was intentional discrimination and the effect of this law on African Americans and Latinos in this state and all North Carolinians. This, after a week-long preliminary injunction hearing, and I'm taking us back now for one moment. After a week-long preliminary injunction hearing, an appeal to the Fourth Circuit, briefing before the Supreme Court, 2 fulsome trials on the merits held in Winston-Salem in July and January, trials that many of you participated in, so many of you were witnesses, not just in that courtroom, but on the stand, submitting testimony. This is your victory. On Friday, July 29th, 2016, the Fourth Circuit ruled that the challenge provisions of HB 589 were enacted with racially discriminatory intent. I'm repeating what Reverend Barber said, but let us echo this. Let us echo this. On the same day, an injunction was entered. Thank you, my father. On the same day, an injunction was entered. And I just want to take one moment to talk about what that means. Because there are people who have been speaking over the last week about how this is confusing. And I just want to ask folks in this room, is it confusing to return back to the system that you were familiar with? No! Is it confusing to turn back to the system that allowed you to access the ballot in unprecedented numbers in this state? North Carolina voters will return to a system of elections that allowed for the greatest growth in African American and Latino participation in this state since Reconstruction. North Carolina voters will be returning to signature attestation under the penalty of a felony. North Carolina voters will enjoy the full scope of early voting opportunities previously available, up to 17 days. And my colleague Allison Riggs is going to speak in just a moment about the vigilance that is needed to ensure that this victory results in tangible results for people on the ground in every county board of elections plan, every plan that is approved by the State Board of Elections must stand up for the spirit of the Fourth Circuit victory.
That's right.
In closing, I just want to say that about a year ago we came together, and the NAACP brought together plaintiffs, branch members, and we talked about a change in a season of victories of voting rights, and we talked about feeling the wind changing. Last week represented a change in the wind. And it is this movement that gave the wind beneath that change. Politics, in the words of the Fourth Circuit, politics as usual cannot be accepted where politics as usual translates into race-based discrimination. Thank you very much. Thank you for the privilege of representing you, and we will stand with you until this victory is made real.
Forward together. Forward together.
Good morning. Thank you for having me today. My name is Allison Riggs. I'm a senior voting rights attorney at the Southern Coalition for Social Justice. I have had the great pleasure of working with the entire NAACP team, representing the League of Women Voters, the A. Philip Randolph Institute, Common Cause, Unifor One Stop Collaborative, the grassroots group.
That's right.
Groups across the state that have joined together, starting with the HK-on-J movement, the Moral Monday movement, that have been fighting for justice in this state for years. And a week ago was a cherry on top, but it is part of this bigger struggle of what we've been doing in this state, building cross-racial coalitions and fighting for justice for all. I'm going to talk just for a few minutes about next steps, because just like you, I celebrate this victory. It means, to follow up on what Reverend Barber says, this decision means Shelby County was wrong.
Yeah, that's right, wrong.
Chief Justice Roberts implied we live in this post-racial society where voting discrimination on the basis of race doesn't exist. It does. And the Fourth Circuit Court of Appeals unanimously agreed. So my big point here is going to be urge vigilance. We can't give up on the Voting Rights Act. We can't give up on demanding the Voting Rights Act be fully restored. But now we're going to see the fruits of our victory in the election in November, and we can't let our guard down. Vigilance is demanded. So there's a few things we need to do. On Monday and Tuesday in Concord, North Carolina, the State Board of Elections will be training all 100 county boards of elections on the new election laws. We will be there. We will be demanding that they're accurately reflecting what the state of the law is, what the spirit of the law is, and the spirit of the law is this. Voting opportunities are restored to the way they were before this discriminatory law, which means that we get 17 days of early voting, not just at county boards of elections. That was not the law before House Bill 589. It means that people will not be turned away because they don't have ID. This is not a hard change. You don't ask for ID. I could teach a 5th grader how to implement the new law. It means that same-day registration is in effect. If you are not registered, you can get registered during early voting. It means that 100,000 people who would otherwise be turned away in October and November get to participate in the political process. It means that if you can't get to the correct precinct on election day, you still get to vote. Your right to vote isn't dependent on your ability to get a ride.
That's right.
The vigilance that we need to employ now is, first and foremost, in the next 2 weeks, each 100 county board of elections is going to be looking at their early voting plan. Reverend Barber mentioned Guilford's already up to mischief. We had 22 early voting sites in 2012, 21 of which offered Sunday early voting.
Yes.
They want to get rid of Sunday early voting. They want to reduce the number of sites to 12, almost in half. North Carolina has grown by almost 500,000 people since the last presidential election. Guilford County has increased by 25,000 since the last presidential election. North Carolina is going to serve more early voters this election than they ever have before. If the counties are allowed to get away with this, lines will be ridiculous.
That's right.
We're not going to stand for it. We will stand up at these county board meetings. We will advocate.
Yes.
We will say that the spirit of the law is that this cut to early voting was racially discriminatory.
Yes.
Counties can't get away with what the Fourth Circuit said no.
Yes.
So everyone needs to be paying attention to what's going on in your county. You need to go to your county board of elections meetings. You need to tell them how important early voting sites are, how important early voting hours are, how important Sunday early voting hours are. We cannot be complacent.
That's right.
The other thing that we need to do is Democracy North Carolina and the NAACP run a monster election protection effort. During early voting and on election day, we need to have people out at the polls.
Yes.
That's right.
We need to be watching.
Yes.
This is how we won the case too. I mean, we had folks everywhere gathering witnesses, identifying problems, documenting everything. We can't let our guard down. We have to keep doing this. So please talk to Reverend Barber, talk to your leadership in the NAACP, talk to Bob Hall. See how you can get involved in making sure that everyone has a good voting experience in November and everyone gets to participate. And in setting the course for this state, for saying we have this court ruling, we're going to elect officials accountable to us who will enact policies that reflect our values, our goals for this state. No more racial discrimination in voting. We're going to expand access to the franchise, and we're going to hold people accountable at the ballot box.
Not one step back. Not one step back. All right. Now all right, that's my brother from Winston-Salem. Now, we're going to have our plaintiffs speak. I want to note that from today to August 28th, which is a Sunday, which is the 53rd anniversary of the March on Washington, we're not going to just commemorate this year. Right. After 12 o'clock today, we need everybody to stay. We're going to be engaging in massive planning on how to do voter registration, voter protection, because now that we have won the case, we must use what we have won. And we must protect what we've won. And we must have millions to march to the polls. And we must have hundreds to march into these boards of elections. We are imploring the media to go and cover these boards of election meetings and to help protect so that everything that's done is done in the light and not in the dark. So how many of you are going to stay the whole day? Raise your hand. Yeah. Because our excitement must now be turned into effort. Is that right? We are coordinating 1,300 churches, synagogues, temples, and mosques to be a part of our Souls to the Polls effort. We're coordinating thousands of volunteers. We're registering thousands of voters. Ms. Carolyn Q. Coleman is the chair, asked her to serve as chair of that effort with our vice presidents and others. You're going to be introduced to our consultants. After this, the plaintiffs speak, then the lawyers will take questions. I have to go to do a piece on MSNBC because they're talking about this today with Joy Reid, and she wants to help us make sure that people know what's going on here. I'll come right back this afternoon. We're going to have breakout sessions because we are, one good thing about NAACP, we are a family, not just a person. And we can be, and then when you add our 200 coalition partners from the Forward Together Moral Movement, we're not only a family, we are a movement that can get things done. So I'm going to leave, if there are no questions from me, I'm going to ask the attorneys to take questions. Caitlin is going to facilitate from here, Ms. Coleman, and Ms. Perry, and Ms. Eaton, and she will facilitate, and I'm going to step out. Afterwards, the attorneys are going to have a workshop with us because people perish for the lack of knowledge. So we want everybody to get an understanding of where we are and what we must do. Forward together.
Not one step back.
Caitlin.
Thank you, Reverend Barber. We are now going to hear from one of our lead plaintiffs, Carolyn Q. Coleman, who needs no introduction.
This is a wonderful day.
Yes.
A day when we celebrate much of the work that we've done over the last 3 years. I don't know how many of you remember that we have started in North Carolina a movement that's been replicated across this country with the Moral Monday movement. And from that we filed a suit. We have won a marvelous victory. Reverend Barber talked about the data that they carved out that impacted us. The one thing you didn't hear anything about that we don't participate as much as we should is absentee ballots. They didn't bother that because we don't vote by absentee ballots as often as we should. So they didn't touch that. Well, you know who votes by absentee ballots. Now, Attorney Rigsby said that maybe 100,000 people will have their votes counted that would not have had them counted had we not won the suit.
That's true.
Now let's talk about what 100,000 votes will do. 100,000 votes may mean that we will have an opportunity to elect a president of our choice who will appoint maybe up to 4 Supreme Court justices. Think about it now. 100,000 votes will mean that we can bring the governor back to Charlotte. I want you to hear what I'm saying. 100,000 votes will mean that he can go back to Charlotte.
There you go.
Now, 100,000 votes will mean that we can bring Tillis home the next time. We can bring Burr home the next time. I'm talking about people that have opposed us. I'm not talking about partisan elections. I'm talking about people who spoke against what we were trying to do. 100,000 votes will mean that we won't have city council people, county commissioners, and school board members that don't support some of the things that we support. Now, I'm from Guilford County, and I can tell you that 100,000 votes would have meant that we would not have that board of elections there that's trying to make the changes to cut out some of the local voting places that we have for early voting. 100,000 votes, people, will mean the difference in lives and communities. So then what we do between now and November will make a difference in what happens in our lives. Now the woods are lovely, dark and deep, but we have miles to go before we sleep. Yes, miles to go before we sleep. And I continue to tell you, this is no time for sleeping. We don't have time to sleep. I don't know about you. I'm up until 1 and 2 o'clock in the morning on the phone doing the people's work. So I say this is marvelous. I want to thank the attorneys that won this suit for us. And you know, it's just wonderful as a woman to see so many women that were involved in this case. I like to call it woman's power.
Amen.
I want to thank Reverend Barber for his leadership, and I also want to thank the other plaintiffs. I won't take any more time, but call the others to the mic.
Thank you. Thank you, Carolyn Coleman. We are now going to hear from Mrs. Rosanelle Eaton. who has been not just a lead plaintiff in this lawsuit, but a symbol for all of us of someone who would not sit down. Yes. Mrs. Rosenelli.
Thank you. Good morning to everyone. Good morning. I'm glad to be here today, and I hope you are too. This is a day that the Lord has made. Let us be glad and rejoice in it. This is a day of victory for some and amazement for others. But this is our day when we celebrate the people's victory. As you have known that I have been out here ever since 2010. Actually, 2008. Doing the same things that I'm doing now. Yes. And I have persuaded and tried to persuade a lot of people to get involved before this ever happened. I was in the position to find out about this in 2010, that their intentions were to set us back, take our rights away, and name it something, whatever. So I began working. I didn't begin working then. I began working when I was 19 years old. And I guess you all know, if you looked at the phones and looked at the television, that I've been out here quite a while. And I am looking at people that I've never seen before. But I want to see you some more. Just like Sister Coleman said, that we need to be involved. You need to be motivated. If you need that, it's out there for you. And if we attend meetings like we should, because I don't want to tell the story of my life, but I went back when I was 19 years old, finished high school, and got registered in a hard way, alone, to try to prepare for this day or a day, because I know there were racist people in the world, and I know we were going to have to fight. So I got out there and fought with Dr. King. We fought everywhere in Western Salem, didn't fight in Africa, but one of the wonderful governors sent me over there, and we registered people there. And we did a whole lot of things when I was young. But now I'm old, but I'm still out here. As you know, I'm 95 years old. On the road ever since I was 70 or before, fighting and for the people of the world. That was my calling, I think, because I just laid down everything before. But let me tell you something. In the beginning, the other night, when they announced something about some fraud, I said, why they keep lying? Because I got on the stand and stayed on the stand at the courts. And I explained to them that that was no fraud. We had a little conflict in the system once upon a time, about 25, 30 years ago, concerning a mixed up on names. But there was no fraud. They put all of this, as it has been told. But I want to tell you what I got up there in the hot seat and told them, time after time, is that they were doing that to set us back. Every time a lawyer would get up, they would do, we got to go back to South Carolina. When I had been to South Carolina, and Selma, and everywhere down in Mississippi, trying to elevate them up to a higher standard. And they wanted to put us back. That irritated me. I would look at those 8 lawyers and say, why would they want to do that? The thing of it is, they want to set you back and set you out. Now, if you don't want to get involved, it's just your private art to whatever you want to do. But the thing of it is, you must do that. You must get involved and be a committee. I talk to people all over the world. I talk when I go to shopping, grocery shopping, every shopping. I go in places and ask, what are y'all doing? And they'll say, well, we are just talking. But then, what are you talking about? And get involved in that. You got to open up your mouth and be a committee of one. I can tell you, and I have made many of speeches all across the world and all across North Carolina and everywhere concerning things like that. And in prizes of Lamplights Awards and things of that nature. And they be loud and clear and Gaelic. But when it comes down to talking about humanitarian and getting people to vote, to get quiet. So I don't want you all to get quiet. I came here to tell you today to wake up. A lot of people act like they sleep. If they're not asleep, get involved. Learn. Read. You can read. Read if you can't read. Be like I was when I had an operation on my right eye last year. My daughter had to read 72 litigations to me from the lawyer for me to learn, and I learned them. And when I went up to talk to them, we've been on the road for 3 or 4 years constantly. And I knew them all. So you can learn. You all, everybody in here looks younger than I are younger. So get involved and get waking up and get ready to fire up. Wake up! Wake up! Fire up! Fire up! Wake up! Wake up! Fire up! Fire up! All right, do that with us. Thank you so much for coming. Get involved in everything you do.
I hope that Mother Eaton got to see the standing ovation in this room for her words and for her hard fight. I know that we are coming to a close, but there is one more person who is an unsung heroine of this case, and that is Mary Perry. Many of you know her from her tireless work across this state. Amen. The number of people who she has personally registered to vote and brought to the polls exceeds my imagination. Wow. Mrs. Mary Perry.
To God be the glory for the great things He has done. Nothing but the Lord. He brought me this far. He didn't bring me this far to leave me. May the work I've done speak for me. I am so glad that the Lord enabled me to be able to go to trial every day. We were up there for 3 weeks. Came back and went back again. Then we went up to Richmond, Virginia. Nothing but the Lord. You know, Miss Eaton told you and the others have told you so many things that but the main thing I want to tell you is that we have got to get out and register people to vote. Yes, I have registered over 10,000 people.
That's right.
My latest one was yesterday. I met a fellow on the street, and I said, "Son, are you registered to vote?" I said, "No, you aren't registered to vote. Come on, let me go to my car and get my computer." I registered, young man. And that's what we've got to do. Because some of the people that's trying to get in the White House, we got to see that they don't get there. And you know who that is. But I ask you that God gave me the strength, the determination, and the will to do what He would have me to do. And I'm like Ms. Eden. I'm 86 years old. I'll be 87 in October. So if I can get out there and register people, you can too. And it's not like it used to be. When we first started registering people, it was hard. And you had to go through a lot of things to be able to do the job. And now you can get the ballots, put them on a clipboard and carry them with you everywhere you go and register people. And I want to tell you, Reverend, you got some people in your church that's not registered. Because I know I got some in mind that's not registered. And what's so bad about it, they say they're not going to register. But I tell you what, until the last day, I'm going to wear the daylights out of them. Because we have got to register, and then we got to go to the poll and vote. And friends, don't forget your people in the rest home. Some of them are already asking for absentee ballots. Get those absentee ballots to them. Let's do what we got to do. Thank God that He gave me the strength to keep on keeping on. And I bless you all. And as you leave this place today, everybody in here promise that you will register at least 2 people.
That's right.
Can you promise me that? At least 2 people. Everybody will get 2 people and then take their in turn and get some. We'll get the job done. May God bless you.
It's our time. It's our vote. It's our time. It's our vote. It's our time. It's our vote.